Imagine this: your family just lost you. They're grieving, trying to hold everything together. But suddenly, they receive a letter from the court saying your estate is now under probate. Now your spouse can't access your bank account, your children can't sell your home, and everything you worked for is frozen, waiting for a judge to decide what happens next. This isn't a horror story. It's reality for millions of American families every single year. In fact, more than 60% of adults in the US don't have a will, and that means when they die, their loved ones face months, sometimes even years, of legal battles in probate court. But here's the good news: probate isn't unavoidable. In fact, if you understand a few simple legal tools, you can make sure your family gets access to everything quickly, privately, and without paying thousands in legal fees. In this video, we'll unwrap exactly how you can avoid probate in the US and protect your family's financial future. Let's be honest, nobody likes to talk about death, wills, or the legal process that comes after. It's uncomfortable. But the truth is, not planning ahead can leave your family trapped in red tape. Probate is the legal process where a court oversees how your assets, like your home, money, and property, are distributed after you die. Sounds fair, right? The problem is, probate is often slow, expensive, and public. Depending on your state, the process can take anywhere from 6 months to 2 years, and court fees can eat up 3 to 7 of your estate's total value. And because probate records are public, anyone can see what you owned and who inherited it, something most families never realize until it's too late. That's why today's episode of Law Unwrapped isn't just about avoiding a legal process, it's about protecting your family's privacy, time, and emotional peace. We'll break down the most effective ways to avoid probate, from living trusts and beneficiary designations, to joint ownership and transfer on death deeds. By the end of this video, you'll know the exact steps to keep your assets out of probate and your loved ones safe from unnecessary legal pain. To understand why probate exists, let's go back a little. Probate dates to English common law, centuries ago, when property ownership needed royal approval after someone's death. The process made sense then; it prevented fraud and protected creditors. But fast forward to modern America, and probate has become more of a burden than a safeguard. Today, if someone dies without proper planning, the government steps in, not to take your assets, but to control how they're distributed. A judge appoints an executor, who then has to list every single asset you own, notify creditors, pay off debts, file court paperwork, and only then distribute what's left to your heirs. Every step costs time, paperwork, and money, all while your family is still grieving. Now, each US state has its own probate rules. For example, California probate fees can reach tens of thousands of dollars. Florida allows simplified probate for small estates, but it's still public. Texas has independent administration, which helps a little, but it's not full avoidance. So while probate law was designed to protect fairness, it often ends up punishing families that simply didn't plan ahead. That's why understanding how to legally bypass it is so important. Let's unwrap the core question: how can you avoid probate in the US? Here are the most effective, legally sound methods you can use, starting today. 1. Create a living trust. A revocable living trust is the single most powerful way to avoid probate. When you create a trust, you legally transfer ownership of your assets, like your home or bank accounts, into the trust, which you still control during your lifetime. When you pass away, your successor trustee can immediately distribute those assets to your beneficiaries without court involvement. For example, if you own a home in Los Angeles, and it's titled under the Smith Family Living Trust, your heirs can transfer it instantly after your death. No court, no waiting, no fees. It's private, fast, and flexible. 2. Use joint ownership. When two people own property jointly with right of survivorship, the surviving owner automatically becomes the full owner upon one's death, skipping probate. Married couples often do this for homes, vehicles, and accounts. However, joint ownership can create tax or liability issues, so it's important to use it wisely. 3. Designate beneficiaries on accounts. Bank accounts, retirement funds, and life insurance policies let you name beneficiaries directly. When you die, these accounts transfer instantly to the person named, no probate needed. Many Americans forget to update these designations after divorce or remarriage, which can cause major legal conflicts later. So review them regularly. 4. Use payable on death, POD, or transfer on death, TOD, designations. Many U.S. states allow you to register assets like vehicles or real estate as transfer on death. That means ownership shifts automatically to your chosen person upon your death. For example, in Arizona or Ohio, you can file a TOD deed for your house, avoiding probate entirely. 5. Give gifts during your lifetime. Under federal law, you can give up to $18,000 per person per year, 2024, tax-free. This not only reduces your estate size, and therefore probate involvement, but also lets you help your loved ones while you're alive. 6. Use small estate procedures. If your total estate value is below a certain limit, often around $50,000 to $150,000, depending on the state, your heirs can file a simplified affidavit instead of full probate. It's not technically avoiding probate, but it makes the process much faster. 7. Keep records organized. Even the best estate plan fails if no one knows where to find the documents. Create a clear estate binder or secure digital folder that includes your trust or will, property deeds, beneficiary forms, insurance details, passwords, and contacts. Organization is as powerful as any legal tool. Here's how you can take action right now to protect your family. Make a list of all your assets. Include property, cars, accounts, and digital assets. Decide who should inherit what. Clarity prevents disputes later. Consult an estate planning attorney. Even a 1-hour consultation can save you years of trouble. Create a living trust for major assets. It's private, fast, and widely recognized across the U.S. Name beneficiaries on everything possible, especially insurance, IRAs, and bank accounts. Update your documents every 2 to 3 years or after major life events, marriage, divorce, new child. Communicate your plan. Don't keep it a secret. Make sure your family knows where to find the paperwork and what your wishes are. Remember, estate planning isn't just for the wealthy, it's for anyone who wants to make life easier for their loved ones. Let's look at a real-life example. Case 1, the Johnson family, California. Mr. Johnson died without a trust. His estate, valued at $500,000, went through probate for 16 months. By the end, the family spent over $30,000 in court and lawyer fees. Case 2, the Carter family, Texas. They set up a living trust and TOD designations. When Mr. Carter passed, his wife transferred all assets in under 3 weeks, with zero probate costs. According to the American Bar Association, nearly 70 of probate cases could be avoided with proper planning. And here's the most shocking part: the average probate process in the U.S. lasts 16 months and costs 4 to 5 of the estate value. That means for a $400,000 estate, your family could lose $20,000 in fees just because paperwork wasn't done right. Probate isn't just about money. It's about timing, peace, and protecting the people you love most. The best gift you can give your family isn't cash or property, it's clarity. A clear plan means no court delays, no legal confusion, and no emotional chaos. If you've watched this far, you already care enough to plan ahead. Don't wait, start today. Take one small step: talk to an estate planner, set up a trust, or simply update your beneficiaries. Your loved ones will thank you for it, even if they never have to say the word probate. And if this video helped you understand how to protect your family, don't forget to like, share, and subscribe to Law Unwrapped, where we make the law simple, human, and clear.